Students, we can discuss one more problem with regard to the negligence. So, here with regard to negligence, there is one concept is there, that is res ipsa loquitur. That means the accident speaks for itself. That means here there is no need of proving the accident, because the facts of the case, the facts of the case, it is self-evident that there is a gross violation of the defendant's legal duty towards the plaintiff. So the meaning of the res ipsa loquitur is that the accident speaks for itself. So that is the meaning of this principle, this Latin principle. So there we can see one more case law with regard to this negligence concerning to the res ipsa loquitur, that will come under the negligence. So here there is one problem is there. Here the defendant was the owner of a cinema house adjoining to a public road. He had put up a hoarding with wooden frame from the roof of his house projecting onto the road. It fell upon the plaintiff and injured him, decide. So these are all the facts of the case. Here one person, he was the owner of the cinema house and adjoining to a public road. What he has done, he had put up a hoarding with a wooden frame from the roof of his house projecting onto the road. So what happened? The hoarding which fell upon the plaintiff, that is a passerby, and caused the injury to him. So as you know, we have been discussing the problems under these steps, that is FIRC, that is facts, issue, rule, analysis, conclusion. ಅಂದ್ರೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ, ನಾವು ಈ ನಿರ್ಲಕ್ಷ್ಯತೆ ಅನ್ನುವ ಕಲ್ಪನೆಯಡಿಯಲ್ಲಿ ಒಂದು ಸೂತ್ರ ಇದೆ. ಅದ್ಯಾವುದಂದ್ರೆ ರೆಸ್ ಇಪ್ಸಾ ಲೋಕ್ವಿಟರ್. ಅಂದ್ರೆ ಏನಪ್ಪಾ ಅಂತ ಹೇಳಿದ್ರೆ, ಅದರ ಸೂತ್ರದ ಅನ್ವಯ ಒಂದು ಸಂಗತಿಯೇ ಸ್ವತಃ ವೇದ್ಯವಾಗಿರ್ತದೆ. ಒಂದು ಸಂಗತಿಯೇ ಒಂದು ಸ್ವತಃ ವೇದ್ಯತೆಯನ್ನ ಹೊಂದಿರುತ್ತದೆ. ಅಂದ್ರೆ ಆ ಸಂಗತಿಯೇ ತಾನೇ ವೇದ್ಯತೆಯನ್ನ ಹೊಂದಿರುತ್ತದೆ ಅಂದ್ರೆ ಅದೇ ಮಾತಾಡುತ್ತೆ. ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಒಬ್ಬ ವಾದಿ ಒಬ್ಬ ಪ್ರತಿವಾದಿಯ ತಪ್ಪನ್ನ ರುಜುವಾತು ಮಾಡುವ ಅಂತಹ ಒಂದು ಬಾಧ್ಯತೆಯನ್ನು ಹೊಂದುವುದಿಲ್ಲ. ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಏನಕ್ಕಾಗಲ್ಲ, ಏನಕ್ಕೆ ಒಬ್ಬ ವಾದಿ ಪ್ರತಿವಾದಿಯ ಒಂದು ನಿರ್ಲಕ್ಷ್ಯತನ ಅಥವಾ ಬೇರೆ ಅಂಶಗಳನ್ನ ಅಥವಾ ರುಜುವಾತು ಮಾಡಲು ಅಥವಾ ಅದನ್ನು ನಿರೂಪಿಸಲು ಕಷ್ಟಪಡಬೇಕಾಗಿಲ್ಲ. ಅಂದ್ರೆ ಅಲ್ಲಿ ಇರುವಂತ ವಾಸ್ತವಾಂಶಗಳು, ಇರುವಂತ ಒಂದು ಸಂಗತಿಗಳು ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ ಆ ಸಂಗತಿಗಳೇ ಮಾತಾಡುತ್ತೆ. ದಟ್ ಮೀನ್ಸ್ the things itself which will speak, or the accident which itself speak. So this we can see from this problem. So we have simplified this problem like this. The defendant owner of the cinema theater house had put up the wooden hoarding from the roof of the house projecting towards the road. The hoarding fall on the plaintiff, caused injury to the plaintiff. So these are all the facts of the case. That means here I have told you we have to simplify it. That means even though if you don't simplify it is also there will not be any problem. But if we got simplified it, then it will be much more helpful. For example, if you can see here, there the defendant was the owner of cinema house. That means here it is not clear. That means whether the hoarding has been installed on the house, or whether the defendant has got the house near to cinema house or anything. But one thing is certain, that here the defendant was the owner of a cinema house adjoining public road. He had put up a hoarding with wooden frame from the roof of his house. That means probably it has been said that for the advertisement. That means he has got the cinema house. So what he has done, he has put up the wooden frame from the roof of his house projecting towards the road. So the wooden frame, that means you know that advertisement boards will be there, isn't it? So advertisement boards, it contains with the wooden framework and the iron sheets and all those things will be there. That thing you know. So likewise this defendant has also put up the some advertisement hoarding which is projecting towards the road. So what happened? It has fallen upon the plaintiff and caused the injury. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ನಾವೇನು ನೋಡ್ತೀವಿ ಅಂದ್ರೆ, ಪ್ರತಿವಾದಿ ಒಂದು ಸಿನಿಮಾ ಥಿಯೇಟರ್ನ ಮಾಲೀಕನಾಗಿದ್ದು ತನ್ನ ಮನೆಯ ಮೇಲ್ಛಾವಣಿಯಿಂದ ಏನಾಗುತ್ತೆ, ಒಂದು ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗೆ ಚಾಚುವಂತೆ ಒಂದು ದೊಡ್ಡ ಜಾಹೀರಾತು ಫಲಕವನ್ನ ಅಳವಡಿಸಿದ್ದನು. ಅದು ಒಮ್ಮೆಲೆ ವಾದಿಯ ಮೇಲೆ ಬಿದ್ದು ಆತ ಗಾಯಗೊಳ್ಳುವನ್ನು ನಿರ್ಧರಿಸಿ. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ತುಂಬಾ ಫ್ಯಾಕ್ಟ್ಸ್ ತುಂಬಾ ಸಿಂಪಲ್ ಆಗಿದೆ. ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಏನಂದ್ರೆ, ಒಬ್ಬ ಪ್ರತಿವಾದಿ ಅಂದ್ರೆ ಅವನು ಸಿನಿಮಾ ಥಿಯೇಟರ್ ಮಾಲೀಕನಾಗಿರ್ತಾನೆ. ಅವನ ಮನೆಯ ಮೇಲೆ ಒಂದು ಜಾಹೀರಾತು ಫಲಕ ಇರುತ್ತೆ. ಅಂದ್ರೆ ಆತ ಏನಂದ್ರೆ ತನ್ನ ಒಂದು ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಅಂದ್ರೆ ಒಂದು ತನ್ನ ಸಿನಿಮಾ ಮತ್ತೆ ಬೇರೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಒಂದು ಜಾಹೀರಾತು ಫಲಕ, ಅಂದ್ರೆ ಜಾಹೀರಾತು ಫಲಕ, ಅದು ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಬೋರ್ಡ್ ಯಾವ ರೀತಿ ಇರುತ್ತೆ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿರುತ್ತೆ. ಅದು ತುಂಬಾ ದೊಡ್ಡದಾಗಿರುತ್ತೆ. ಕೆಲವೊಂದರಲ್ಲಿ ವುಡನ್ ಫ್ರೇಮ್ ವರ್ಕ್ ಇರುತ್ತೆ, ಕೆಲವೊಂದರಲ್ಲಿ ಒಂದು ಕಬ್ಬಿಣದ ಫ್ರೇಮ್ ವರ್ಕ್ ಇರುತ್ತೆ ಅಂತ. ಅದು ತುಂಬಾ ದೊಡ್ಡದಾಗಿರುತ್ತೆ. ಅದು ಸಾರ್ವಜನಿಕರಿಗೆ ಕಾಣಿಸ್ಬೇಕಲ್ವಾ. ಮತ್ತೆ ಏನಾಗುತ್ತೆ, ಅವನ ಮನೆಯಿಂದ ಅದು ರಸ್ತೆಗೆ ಚಾಚುವಂತೆ ಅವನು ಆ ಜಾಹೀರಾತು ಫಲಕವನ್ನ ಅಳವಡಿಸಿರ್ತಾನೆ. ಅದೇನಾಗುತ್ತೆ, ಅದು ಒಮ್ಮೆಲೆ ಏನಾಗುತ್ತೆ, ಅದು ಯಾರೋ ದಾರಿಲಿ ಹೋಗ್ತಾ ಇರೋ ಮೇಲೆ ಬಿದ್ದು ಗಾಯ ಮಾಡುತ್ತದೆ. ಅಂದ್ರೆ ಇಲ್ಲಿ ವಾದಿಯ ಮೇಲೆ ಬಿದ್ದು ಆತ ಗಾಯಗೊಳ್ಳುತ್ತಾನೆ. ಇದು ಈ ಒಂದು ಸಮಸ್ಯೆಯ ಒಂದು ವಾಸ್ತವ ಸಂಗತಿ. ನಾವೇನೇನು ನೋಡ್ಬೇಕಂತ ಹೇಳಿದೀನಿ, ಇಲ್ಲಿ ಸಂಗತಿ ನೋಡಬೇಕು, ವಿವಾದಾಂಶ ನೋಡಬೇಕು, ನಿಯಮಗಳು ನೋಡಬೇಕು, ವಿಶ್ಲೇಷಣೆ ನೋಡಬೇಕು, ಮತ್ತೆ ತೀರ್ಮಾನಗಳನ್ನ ನಾವು ನೋಡಬೇಕು. ವಿ ಹ್ಯಾವ್ ಟು ಅನಲೈಸ್ ಫ್ಯಾಕ್ಟ್ಸ್, ವಿ ಹ್ಯಾವ್ ಟು ಫ್ರೇಮ್ ದ ಇಶ್ಯೂಸ್. ಇಟ್ ಮೇ ಬಿ ಮೋರ್ ದೆನ್ ಒನ್, ಅಂಡ್ ವಿ ಹ್ಯಾವ್ ಟು see the rule of law or provision of law. Then we have to analyze all these facts, issue rule under the analysis. Then we have to give the conclusion. So in this way, we have to solve the problems with regard to any law subject. So here what we have to see, the facts has been given, facts has been simplified. Now issue before us is that whether the owner of the house could be held liable for the injury caused to the other plaintiff. That means here the question is that, no doubt the owner of the house, that is the defendant, he has installed the hoarding on the top of his house, that is a roof of his house, projecting towards the road. And while installing that one, he has taken all the necessary precautions, isn't it? So he has taken all the necessary precautions. So all of a sudden accidentally, that means this sort of the injuries will happen accidentally. So it has fallen on the plaintiff. Whether here this the falling of the hoarding board on the hoarding on the plaintiff, for that act, whether the plaintiff whether the defendant could be held liable. Here what we have to see, whether the owner of the house, that is defendant, could be held liable for the injury caused to the plaintiff. ಅಂದ್ರೆ ವಾದಿಗೆ ಆದಂತ ಒಂದು ಅನಾಹುತಕ್ಕೆ ಒಂದು ಪ್ರತಿವಾದಿಯು ಬಾಧ್ಯನೇ. ಅಂದ್ರೆ ಅವನಿಗೆ ಯಾವ ರೀತಿ ಬಾಧ್ಯ ಅಂತ ಹೇಳಿದ್ರೆ, ಅವನು ಒಂದು ಜಾಹೀರಾತು ಫಲಕವನ್ನ ಹಾಕುವಾಗ ಎಲ್ಲ ಒಂದು ಜಾಗ್ರತೆಯನ್ನ ತೆಗೆದುಕೊಂಡಿರ್ತಾನೆ. ಆದ್ರೂ ಸಹ ಅದು ಆಕಸ್ಮಿಕವಾಗಿ ಬಿದ್ದು ಒಂದು ವಾದಿಗೆ ಗಾಯ ಆಗುತ್ತದೆ. ಇದರಲ್ಲಿ ನಾವೇನ್ ನೋಡ್ಬೇಕು, ವಿವಾದಾಂಶವನ್ನ ನೋಡ್ಬೇಕು. ಅಂದ್ರೆ ವಾದಿ ಯಾವ ಒಂದು ವಾದವನ್ನ ತಗೋತಾನೆ, ಮತ್ತೆ ಪ್ರತಿವಾದಿ ಯಾವ ಒಂದು ಪ್ರತಿವಾದವನ್ನ ಯಾವ ರೀತಿ ತಗೋತಾನೆ ಅನ್ನೋ ಅಂಶದ ಆಧಾರದ ಮೇಲೆ ನಾವೇನ್ ಮಾಡಬೇಕು, ಒಂದು ವಿವಾದಾಂಶಗಳನ್ನ ರೂಪಿಸಬೇಕು. ದೆನ್ ವಿ ಹ್ಯಾವ್ ಟು ಸಿ ವೆದರ್ ಡಿಫೆಂಡೆಂಟ್ ಓಸ್ ಎನಿ ಡ್ಯೂಟಿ ಟುವರ್ಡ್ಸ್ ದ ಪ್ಲೇಂಟಿಫ್. ದಟ್ ಮೀನ್ಸ್ ಹಿಯರ್ ವಿ ಹ್ಯಾವ್ ಟು ಸಿ ವೆದರ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಓಸ್ ಎನಿ ಡ್ಯೂಟಿ ಟುವರ್ಡ್ಸ್ ದ plaintiff or public in general. So that is one more the issue. That means here we can frame n number of issues. It may be 1 or 2 or 3 also, but here 2 is enough with regard to this problem. And after simplifying the facts, after seeing what is the issue between the plaintiff and defendant, we have to see what is the provision of law, which provision of law will be applicable here. So this aspect will be discussed under the concept of negligence. Probably you may see this the owner of the house is negligent in his act. So here under negligence, one more, the Latin maxim will be applied with regard to the applicable with regard to this aspect. That is res ipsa loquitur principle. That means the accident speaks for itself. The accident speaks for itself. So that is the meaning of res ipsa loquitur principle. That means here there is no need of proving that one. That means the accident, that is the injury happened to the plaintiff, it will be self-evident. It will speak for itself, as seen in the builder's negligence, or as seen in the owner of the builders, owner of the buildings, that is their negligence or house owner's liability. So this we can see under the case law of Municipal Corporation of Delhi versus Subhangwanti. And I have told you in all my previous videos also that we have in provision of law, we have to say what is the rule of law, which the provision of law will be applicable. Here the provision of law will be the negligence concept. So under negligence concept, we have to see res ipsa loquitur principle, and we have to highlight any decided cases with regard to the given problem. Here the normally 70 to 80% problems will be given on the decided case laws only. So here the same, more or less same facts we can see under the case law of Municipal Corporation of Delhi versus Subhangwanti. Here also there is a one clock tower was there. It was running for more than 80 years. All of a sudden it has fallen on the public. Thereby 3 persons they have died in the accident, and one of the persons who has deceased, one of the deceased person's wife, Subhangwanti, she has filed the case against the Municipal Corporation of Delhi. So here the court has applied the principle of res ipsa loquitur principle. Here the court has seen that it is a legal duty of the owner of the building to carry out periodical inspection for the house of determining whether any precautions could be taken. So here it has been observed in the case law of Municipal Corporation of Delhi versus Subhangwanti, it is a duty of the owner of the building to carry out the periodical inspection for the house of determining whether any precautions are needed. So if he doesn't take any precautions, then he will be held liable. And the legal position is that there is a special obligation on the owner, keeping in view of potential danger to the passerby. That means it has the hoarding which is projecting towards the road. That means there is some what you call potential danger would be there. It may fall upon the passerby. So same thing what we see in the Municipal Corporation of Delhi versus Subhangwanti. Here also more or less same facts are there. But in Municipal Corporation of Delhi, it is about the clock tower. Here it is with regard to the hoarding. So here also the same thing will be applied. Same provision of law can be applied with regard to the present case law. So if the defendants could not take the precautions with regard to any potential danger, then they will be held liable. So after we have to analyze all these things with regard to these aspects, with regard to the facts, issue and provision of law. All these things we have to analyze in the analysis section. So we have to analyze all these things in the analysis section. So provision of law and all these things we have to analyze. ಅಂದರೆ ವಿದ್ಯಾರ್ಥಿಗಳೇ, ನಾನು ನಿಮಗೆ ಮೊದಲೇ ಹೇಳಿದಂತೆ, ಹಳೆ ನನ್ನ ವಿಡಿಯೋದಲ್ಲಿ ತಿಳಿಸಿದಂತೆ, ಸಂಗತಿ, ವಿವಾದಾಂಶ ಮತ್ತೆ ನಿಯಮಗಳನ್ನು ನಾವು ಎಲ್ಲಿ ಅದನ್ನ ಚರ್ಚೆ ಮಾಡಬೇಕಂದ್ರೆ ಒಂದು ವಿಶ್ಲೇಷಣೆಯಲ್ಲಿ ನಾವು ಚರ್ಚೆ ಮಾಡಬೇಕಾಗುತ್ತದೆ. ನಂತರ ನಮ್ಮ ತೀರ್ಮಾನವನ್ನು ನಾವು ನೀಡಬೇಕು. ಅಂದ್ರೆ ನಾವು ಮೊದಲೇ ಅದನ್ನ ತೀರ್ಮಾನವನ್ನ ಕೊಟ್ರೆ ನಮಗೆ ಅದು ಯಾವ ಒಂದು ನಮ್ಮ ಒಂದು ತೀರ್ಮಾನದ ಒಂದು ಬುನಾದಿ ಯಾವ ರೀತಿ ಇರುತ್ತಂದ್ರೆ ಅದಕ್ಕೆ ಒಂದು ತರ್ಕಬದ್ಧವಾಗಿರೋಲ್ಲ, ಮತ್ತೆ ಅದರಲ್ಲಿ ಒಂದು ಲಾಜಿಕಲ್ ರೀಸನಿಂಗ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಮತ್ತೆ ಲೀಗಲ್ ಕಾಂಪಿಟೆನ್ಸ್ ಇರಲ್ಲ, ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಕಾನೂನುಬದ್ಧ ತರ್ಕ ಇರಲ್ಲ. ಇವೆಲ್ಲ ಇದ್ರೆ ಮಾತ್ರ ನಮಗೆ ಪೂರ್ಣ ಅಂಕಗಳು ಸಿಗುತ್ತದೆ. ಅಂದ್ರೆ ವಾಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಸಿ ಇನ್ ದ ಕನ್ಕ್ಲೂಷನ್ the defendant will be held liable, as it is a legal duty of the owner of the building to carry out the periodical inspection for the house of determining whether any precautions could be taken. So here, as we have seen in the Municipal Corporation of Delhi versus Subang Mandi, the case law is that the municipal corporation has to maintain the what you call clock tower. They have to make the periodical inspection. They have to see whether any which will cause any potential danger to the public. So they have not done anything. So thereby, but the act of the defendant itself is it is a negligent one, and they may not have to prove the act of the municipal corporation of Delhi with regard to the concept of negligence, because it is self-evident, because which will be self-evident. That means anyone can say they have not maintained the what you call the building or the clock tower. They have not done periodical inspection. So all those there is a lapses on the part of the defendant, so they will be held liable. So same thing can be applied with regard to the facts of the case or the instant case, that the owner of the building or defendant could be held liable. ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿ ನಾವು ಏನ್ ನೋಡ್ತೀವಿ ಅಂದ್ರೆ, ಈ ಏನು ಪ್ರತಿವಾದಿಯು ತನ್ನ ಕೃತ್ಯಕ್ಕಾಗಿ ಏನಾಗುತ್ತೆ, ಆತ ಈ ವಾದಿಗೆ ಆತ ಒಂದು ಬಾಧ್ಯನಾಗುತ್ತಾನೆ. ಯಾಕಂದ್ರೆ as you have seen, this is also one of the essentials of the negligence. That means when we are discussing with regard to the which are the essentials of the negligence, so there the first aspect is duty to take care. That means the defendant must owe a legal duty towards the plaintiff. Either he may be the plaintiff or general public, and that is he has got the duty to take care, and he has got the test of foreseeability also we can see, and he has breached in his duty to take care. That is also one of the essentials of the negligence. So by the breach of his duty, that is a respondent or defendant's breach of duty, the plaintiff has suffered the damage, so that the defendant would be held liable for the damages caused to the plaintiff. So in this case, the plaintiff can he can claim the compensation against the defendant. So this is with regard to the res ipsa loquitur, the Latin maxim, as well as the concept of negligence. So in our future classes, we can complete as many as problems with regard to the question papers which has been given in the Karnataka State Law University examination.